Judgment in the matter of KV Sri Lanka versus Secretary of State for the Home Department.
Lord Wilson will explain the decision of the court.
KV is a national of Sri Lanka who came to the UK in 2011 and made a claim for asylum which the Home Secretary refused. The Immigration and Asylum Chamber of the Upper Tribunal dismissed KV's appeal against the refusal, and the Court of Appeal dismissed his appeal against the Upper Tribunal's decision. So he appeals on up to us. The basis of his claim is that he is of Tamil ethnicity and that in Sri Lanka he had given assistance to the Tamil Tigers, then an insurgent political movement there, as a result of which he had been interned and tortured by government forces. He says that there is a real risk of further persecution of him if forced to return there. The main evidence supporting his account of torture is a series of deep scars across his back and on his right arm, which, he says, are the product of hot metal rods which the government forces had held against his skin while he was immobile. The tribunal found his account to be generally unconvincing. In particular, it didn't accept that the scars were the result of torture. In effect, it concluded that he had asked somebody to burn him with hot rods in an attempt to manufacture evidence for his intended asylum claim. This sort of wounding is called SIBP, self-inflicted by proxy, and for obvious reasons, it is very rare. In reaching that conclusion, the tribunal rejected the evidence of a medical expert who, following examination of KV's scars, offered the opinion that they were highly consistent with his account of torture. In particular, the expert relied on the different appearance of the scars on the back from those on the arm, which in his opinion closely tallied with KV's detailed account of the sequence in which the injuries had been inflicted and of the point at which they had rendered him unconscious. Today, we unanimously allow KV's appeal and direct the tribunal to reconsider the appeal which he made to it. The general importance of our judgment lies in our rejection of observations made by the Court of Appeal about the expert's evidence. It observed that he had exceeded his proper role in offering the opinion that the scars were highly consistent with KV's account of torture. We hold that, in reporting to our courts and other decision makers about the significance of scarring, experts should follow the Istanbul Protocol, endorsed by the UN in 2000, which specifically encourages them to offer that sort of opinion if it is within their expertise and if they feel able to do so. But our reasons for allowing the appeal, although very important to KV, are of little general importance. We held reluctantly that there were significant flaws in the tribunal's determination. In expressing its conclusion, the tribunal appeared to lose sight of KV's account of the sequence of the alleged wounding on which the expert had set such store. And when confronted with the choice that his scars reflected either torture or wounding SIBP, the tribunal catalogued its reservations about the likelihood of his account of torture without balancing them against the factors which may suggest how unlikely it is that he would have arranged for the infliction upon him of no less than 5 hugely painful injuries.
Thank you. The court will now adjourn.